Imagine yourself standing in a family courtroom anywhere in America. The location doesn't really matter anymore. Those harsh fluorescent lights buzz overhead with that distinctive hum that seems to be standard issue in every family court across the country. Your son sits at the petitioner's table. The same boy you taught to ride a bike, whose college loans you co-signed, who wore that slightly ill-fitting tuxedo on his wedding day. He's not crying anymore. He's moved past tears. There's a hollow look in his eyes, the expression of someone who has already calculated what's coming and knows there's no escape. Sitting across from him is his ex-wife. You never trusted her from that first Thanksgiving back in 2019, when she looked at your wife's pumpkin pie with barely concealed disgust. The same woman who somehow forgot to invite you to your grandchild's birthday party a few Christmases ago. She sits upright, composed, almost smiling. Her attorney, dressed in a suit that probably cost $4,000 and bills at $850 an hour, sits confidently beside her. She's about to receive a substantial payday. Then the judge, someone who has processed thousands of these cases with all the emotional engagement of someone issuing parking tickets, strikes the gavel. That single sharp crack of wood echoes through the courtroom, and in that moment, 40 years of your sacrifice evaporates. 4 decades of waking up before 5 in the morning. 4 decades of canceled vacations. 4 decades of driving an aging vehicle through brutal summers because every dollar you saved on yourself was a dollar you were setting aside for him, for the next generation, for your family's future. The judge orders your son to pay $250,000. $250,000 of your life's work flows directly into the bank account of the woman who called you a parasite at your own retirement party. You didn't leave a legacy for your son. You financed her new lifestyle. You essentially purchased her luxury car and put a down payment on the vacation property she'll share with her new partner. This isn't metaphorical. This is the literal, mechanical, mathematical reality of what just transpired in that courtroom. The worst part, the truly devastating truth that will keep you awake staring at the ceiling, is that you enabled this outcome yourself. You set it in motion the day you walked into that strip mall law office and signed a simple, last will and testament that left all your assets to your beloved son outright, with no protective structures in place. You signed it with satisfaction, probably thanked the staff warmly on your way out. And with that signature and notary stamp, you gave a complete stranger, a family court judge who has never met you or your son, who knows nothing about how you postponed your own medical procedures to keep saving, the legal authority to redistribute your wealth to someone you would never have chosen. This is what I call the ex-spouse trap. In 2026, with divorce rates still hovering around 50%, this trap is no longer an unusual horror story. It's a statistical coin flip, the probable destiny of half the inheritances changing hands in America today. Half of them. And almost nobody warns you about this. Not your accountant, not your insurance agent, not the estate planner who sold you that standard revocable living trust package for under $2,000 in an attractive folder. Why doesn't anyone warn you? Because doing so isn't profitable. The mass market estate planning industry operates on volume. Volume of simple wills. Volume of straightforward distributions. Volume of grieving children walking out of probate court with paper checks that they will, with near certainty, deposit into joint checking accounts with their spouses within days, because that's what normal people do. When you receive a check, you deposit it. When you're married, your checking account has both names on it. That's standard practice for married couples. In that single deposit transaction, the instant the bank teller processes it, your inheritance becomes commingled marital property under the laws of 41 states. 41 states. This should make you absolutely furious. If you're not angry right now, you need to examine whether you truly understand what's at stake, because the mechanisms that drain family wealth are already in operation. Before I explain exactly how a $500,000 inheritance becomes a $250,000 divorce settlement check to your son's ex-wife within just a few years, I need to address something important. The estate planning and divorce law establishment doesn't want this information widely available. Every family court judge who has built a career processing these cases, every matrimonial litigation specialist billing premium hourly rates, They all prefer that families remain uninformed about what I'm about to explain. We are about to dismantle their most predictable revenue stream. Now let me be absolutely clear about something. This isn't official legal advice. This is a survival guide for navigating a legal system that has spent the past 60 years quietly evolving to extract maximum value from families during their most vulnerable moments. If you still believe the family court system functions as a neutral arbiter of fairness rather than a wealth redistribution mechanism with legal authority, then by all means consult an estate planning attorney. Just ensure it's not the same one who sold you that $2,000 standard package. Find one who actually understands what a spendthrift trust is. Most of them genuinely don't. I'll return to this point. Here's what they don't tell you. When you leave money to your child as a direct distribution, meaning the check goes from your estate directly into your child's individual hands with no protective legal structure surrounding it, that money legally transforms into what's called fee simple absolute ownership. Fee simple absolute. Remember this phrase. It's critically important. Fee simple absolute means your son owns that money exactly the same way he owns his toothbrush, completely and totally, with every legal right and every legal vulnerability that comes with full ownership. He can spend it, lose it, have it taken from him, and statistically will commingle it with marital assets. Commingling is the critical term here. It's the legal mechanism that transforms separate property into marital property. Commingling, in family court terminology, is the act of mixing what was once separate property, meaning property your son owned individually before or outside the marriage, with marital property, which is anything earned or acquired during the marriage. Most states, including the major ones like Florida, California, Texas, New York, Illinois, and Pennsylvania, operate under what's called the transmutation doctrine. Transmutation might sound like something from fantasy fiction, but it functions more like a financial nightmare. Transmutation is the legal principle stating that when separate property is mixed with marital property in a way that makes the two indistinguishable, the entire amount becomes marital property. The whole amount. Not half, not proportionally, the entire sum. Let me illustrate with specific numbers, because this is where the reality becomes truly outrageous. Your son inherits $500,000. He receives a check with only his name on it. Your estate plan was at least that competent. He walks into his local bank branch on a Tuesday afternoon. He approaches the teller and says he'd like to deposit the check. The teller asks which account, and he, being a normal, trusting, well-adjusted married American, says the joint checking account. The teller processes the transaction, prints a receipt, and he goes home. He tells his wife the inheritance came through and he's deposited it. She suggests paying off the mortgage. He agrees. They pay $180,000 toward the mortgage. They invest $50,000 in a kitchen renovation. They put $40,000 into college savings plans for their children. They place the remaining $230,000 into a joint brokerage account, also under both names. 3 years later, she serves him with divorce papers. She's been planning this for 18 months. He had no idea it was coming. Now here's the critical question every person planning their estate needs to internalize. How much of that $500,000 is still legally his separate property? Zero. The answer is zero. Not a single penny. Because every dollar of that money was commingled. The mortgage payoff increased equity in a marital home, which is marital property. The kitchen renovation improved the marital home, also marital property. The college savings plan was funded jointly, making it marital property. The brokerage account was titled jointly, definitively marital property. Through the rules of transmutation, the entire $500,000 has been legally converted into divisible marital assets. The court begins the divorce proceeding with a presumption of 50-50 distribution on every dollar. She walks away with $250,000 of your retirement savings, plus potentially alimony, plus half the house equity, plus other marital assets. This isn't a worst-case scenario. This is the median outcome. This is what happens to approximately 50% of inheritances in America today. Now, I want you to consider your own situation. Are you concerned about your children's spouses potentially gaining access to your hard-earned savings? Have you witnessed this scenario play out with friends or family members? Have you seen a substantial inheritance evaporate into a divorce settlement in your own extended family? Let me introduce you to the three predators circling your child's inheritance the moment you sign that simple will. Because the ex-spouse, as problematic as she is, represents only the first threat. Predator 1 is the ex-spouse. We've just covered her playbook. She has a 50% statistical likelihood of appearing in your child's life. She uses transmutation, commingling, and the marital property doctrine to legally convert your money into her divorce settlement. She's patient and doesn't need to do anything illegal. She simply needs to wait for her husband, your son, to do what every normal married American does, which is deposit a check into a joint account. The moment the bank processes that transaction, your inheritance becomes vulnerable. Predator 2 is the creditor. This threat is potentially even more terrifying because it requires no marriage whatsoever. Imagine your son driving home from a sporting event. He's tired but sober. He proceeds through a yellow light and accidentally strikes a pedestrian. The pedestrian survives but suffers a traumatic brain injury requiring $4 million in lifetime medical care. The pedestrian's family hires a personal injury firm. They sue your son and obtain a judgment. The judgment exceeds his auto insurance coverage by $3.2 million. The court issues a writ of execution, which allows the plaintiff's attorney to attach every non-exempt asset your son owns. His brokerage account, his savings, the cash equity in his house above the homestead exemption. Every penny of your inheritance disappears, going to a stranger and to a personal injury attorney's contingency fee. Let me be clear about something important. This can happen to a completely responsible adult. A car accident, an incident involving a pet, a slip and fall on rental property he owns, a failed business partnership that results in litigation, a professional malpractice suit if he works in certain fields, or even an intensive audit if he's a contractor. The American legal system in 2026 represents a more aggressive creditor environment than at any point since the Great Depression. Lawsuits are increasing, settlements are growing, and your son's directly inherited cash sits there completely exposed with absolutely no legal protection. Predator 3 is the one nobody wants to discuss because it makes family gatherings uncomfortable. It's the child themselves, your own flesh and blood. I'm sure your son is a wonderful person, but statistically, in 2026, 1 in 12 adult Americans has a substance use disorder. 1 in 15 has a gambling problem, and roughly 30% of inherited wealth is liquidated within 2 years of receipt by the recipient. 2 years, that's the median time frame. Half of inherited wealth disappears even faster. People purchase boats they don't need. They invest in questionable business ventures with friends or relatives. Some develop substance dependencies in middle age because they've never had liquid assets before and don't know how to manage them responsibly. This isn't me being harsh about your child. This is me reading actuarial data. The direct distribution model assumes your child has the financial discipline of a Carnegie or Rockefeller. Most people have the financial discipline of lottery winners. And we all know how those stories typically end. So you face 3 predators: the ex-spouse, the creditor, and the child's own worst impulses. And the simple will, that $2,000 standard package, does absolutely nothing to defend against any of them. 0 protective measures. You might as well leave the inheritance in an unguarded bag in a public location. This should make you absolutely furious. And before I reveal the legal protection mechanism, the actual structure that wealthy families have been using since the 1930 seconds, the thing your estate planner failed to mention, I need you to do something. Share this information with one friend. Just one. Choose the friend who's proudest of his simple last will and testament. Pick the acquaintance who mentioned getting his estate plan handled through a discount legal service for under $100. Send this information to him today, right now, while you're thinking about it. Because every day he remains uninformed is a day his children are vulnerable. You could be saving his family's legacy. One conversation now potentially saves his family $250,000 later. Now let's discuss the protection mechanism. Let's talk about how the genuinely wealthy, the actual financial dynasties, not the upper-middle-class families pretending to be wealthy. Protect this exact same money from these exact same three predators. Your local standard attorney is going to be extremely unhappy about me explaining this publicly, because once you understand it, you will never sign another simple will. The mechanism is called a Spendthrift Trust, sometimes incorporated within a broader discretionary trust structure. This combination represents what professionals call the ultimate protection for generational wealth transfer. Here's the fundamental principle, and I'm going to explain the mechanics clearly, because the power is in the architecture. When you leave money directly to your son, he owns it in fee simple absolute. We've covered this. He has full legal title. The money is his. And because it's his, it's exposed to anyone who can legally attack him. A divorce court, a creditor, a bankruptcy trustee, a tax lien, a personal injury judgment. But when you leave that same money inside a properly drafted spendthrift trust, something legally powerful happens. The trust itself, a separate legal entity like a private corporation with its own tax identification number, owns the money, not your son. Your son does not hold fee simple absolute ownership over a single penny. What your son holds instead is something called a beneficial interest. Beneficial interest is the legal right to receive distributions from the trust on terms you establish as the grantor, administered by a trustee, which can be a corporate trustee, a trusted family member, or an independent professional. Your son can receive money from the trust. He can benefit from it. He can use it for his life needs. But he does not own it. The trust owns it. Now here's the brilliant legal structure of the Spendthrift Clause. The Spendthrift Clause is a specific provision, typically 1 or 2 paragraphs, incorporated into the trust document. What this paragraph essentially states is that no beneficiary of this trust may assign, pledge, transfer, or encumber their beneficial interest. And no creditor of any beneficiary may attach, garnish, or otherwise access the assets of this trust. That's the entire mechanism. It declares that your son cannot give this money away even if he wants to, and his creditors or adversaries cannot take this money even if they sue him successfully. Why does this work? Because of a centuries-old principle in trust law stating that a creditor of a beneficiary cannot have any greater rights than the beneficiary himself. And if the beneficiary cannot voluntarily transfer his interest because the Spendthrift Clause forbids it, then the creditor cannot involuntarily seize it either. The legal logic is airtight. It has been tested in courts for over 150 years. It has been upheld by the United States Supreme Court. It's the same legal mechanism used to protect the assets of trust fund beneficiaries, from the Vanderbilts to the Waltons. Now apply this to our 3 predators. Regarding Predator 1, the ex-spouse. Your son gets divorced. Her attorney subpoenas his bank accounts. They find no inheritance because there is no direct inheritance. There is a beneficial interest in a trust. Her attorney asks the family court judge to attach the trust assets. The judge, who understands trust law, denies the motion. Why? Because of the Spendthrift Clause. The trust assets are not marital property. They were never marital property. They were never your son's property in the first place. The court has no jurisdiction to access them. She walks away with half of what your son and she actually built together during the marriage. That's fair. That's the reasonable outcome of marriage dissolution. But she does not, cannot, and will never access your $500,000. Regarding Predator 2, the creditor, same principle applies. The personal injury plaintiff's attorney files the writ of execution. The writ gets denied regarding the trust assets. The Spendthrift Clause provides complete defense. The creditor's attorney attempts to pierce the trust, fails, and settles for the available insurance limits. Your $500,000 remains untouched. Regarding Predator 3, your son's own poor decisions. The trust's discretionary distribution language, usually built around what's called the HEMS standard, which stands for Health, Education, Maintenance, and Support, gives the trustee authority to release money for legitimate life needs, but withhold money for destructive purposes like substance abuse or highly questionable investments. If your son is in a good place mentally and financially, the trustee distributes generously. If your son spirals into a gambling problem or substance dependency, The trustee restricts distributions. The money survives until he gets his life back together, and then it's still there, waiting for him. This isn't theoretical. This is the actual structural legal architecture that the top 0.1% has been using since the Great Depression. It costs approximately $3,500 to $9,000 to establish a properly drafted spendthrift trust with a competent estate planning attorney. Yes, you have to pay more for a qualified professional, not the discount legal service. And in exchange for that one-time cost, you protect your $500,000 against 3 predators that have a combined statistical likelihood of attack approaching 90% over the next 30 years. Now let's address the obvious objection I hear every time I explain this structure. People say, but I want my kids to actually use the money. I don't want them locked out of their own inheritance. I don't want them having to ask some trustee for a check every month like a child asking for an allowance. This is a fair point and a legitimate concern. Here's the answer. A properly drafted spendthrift trust is not a prison. It's a fortress with wide gates that open for the right people at the right times for the right reasons. Under the HEMS standard, health, education, maintenance, and support, the trustee can fund essentially every legitimate life expense your son will ever encounter. He needs a down payment on a $700 house? The trust can purchase the house outright in the trust's name and allow him to live in it rent-free for life. That house, by the way, is now also creditor-protected and divorce-protected because it's owned by the trust. He needs to put his daughter through medical school? The trust pays the tuition directly to the university. This is tax-efficient and creditor-proof. He needs a new vehicle? The trust purchases it. He needs to start a business? The trust capitalizes a separate limited liability company for him to operate. He needs medical care, surgery, therapy, anything health-related? Distributed from the trust under the health component of HEMS. He needs ongoing living expenses, vacations, normal lifestyle costs. Maintenance and support, distributed monthly or quarterly at the trustee's discretion. Your son lives comfortably, potentially even luxuriously. He just doesn't legally own anything outright that an adversary can attack. That's the difference between wealth and protected wealth. The middle class leaves wealth. The genuinely elite leave protected wealth. And here's the final critical point I want you to understand. The reason the mainstream estate planning industry doesn't emphasize this approach, the reason your local attorney sold you the $2,000 simple will package instead of a $7,000 spendthrift trust, is that simple wills are high-volume, low-margin products. Trusts are low-volume, high-skill products. The standard practices that dominate suburban America are not staffed to handle complex trusts. They cannot draft them properly. They cannot administer them. They cannot defend them in court. So they sell you what they can sell, which is the cheapest, most mass-produced legal document in American jurisprudence, the last will and testament. And they send you on your way with a smile. That's it. That's the entire situation. That's why your retired neighbor with the boat in his driveway has a simple will, and the person who actually owns the marina has a dynasty spendthrift trust with multiple layers of asset protection. You have a choice before you. You can keep what you have and hope your kids never get divorced, never get sued, and never make a serious financial mistake in their 40s or 50s. Statistically, given the 2026 divorce rate, the current litigation environment, and the actuarial data on substance abuse and financial mismanagement, you're essentially hoping for an extremely unlikely outcome. Don't hope. Plan. Schedule an appointment with a qualified estate planning attorney this month. Not next month. This month. Bring this information with you. Tell them you want a spendthrift trust with a HEMS distribution standard, an independent corporate trustee, and full creditor protection language. If they look at you like you just spoke a foreign language, leave and find a different attorney. Qualified attorneys exist. They are findable. The American College of Trust and Estate Counsel maintains a directory of qualified professionals. Use it. And before you finish reading, understand that every week, more information emerges about the legalized wealth extraction mechanisms operating constantly against American retirees. The standard estate planning industry, the family court system, the creditor attorneys, the Medicaid recovery teams all have entire ecosystems built around extracting generational wealth from families that didn't know better. The ex-spouse trap is real. The Spendthrift Trust is the solution. And your simple will is right now, as we speak, sitting in a drawer somewhere, potentially positioned to fund a future ex-daughter-in-law's vacation property. Address this issue today. The protective mechanisms exist. The legal structures work. The question is whether you'll implement them before it's too late. Your family's financial legacy depends on the decisions you make right now, in this moment, with the information you now possess. Don't let 40 years of sacrifice evaporate in a single courtroom hearing. Protect what you've built. Your children and grandchildren deserve that protection.